Deputy Jennifer Carroll McNeill.
Thank you, Count Corla. And again, I want to join with other speakers in thanking the Minister and her officials for bringing this forward so quickly and in response to what had been a serious practical problem. The bill has my full support, as do the amendments, and you know that. And the cases have been very difficult. I still have to talk about the other group of children who are not encompassed by this bill, a third category of children who are not accused or witnesses, but who are the siblings of children, of deceased children, and who are not protected by the provisions of this bill. There is a strong privacy case to be made for those children, particularly children whose siblings have died by reason of an NGRI, not guilty by reason of insanity, which of course is not the same as murder, not the same as manslaughter, but something very different. We distinguish that form of that criminal process very, very strongly from everything else. We think about it differently. We treat it differently in terms of sentencing and recovery. And sometimes, as I discussed at second stage at length, the source of that can be, very considerable mental illness. As you know, I've engaged extensively with a family at the core of this case, where there is a sibling and who have been identified again and again in their community and who are trying to rebuild their life. And my concern has always been around the privacy of the younger child. There's a very strong impetus behind driving this bill and behind the discussion around it and the impetus around it, very strongly driven by Article 34 concerns around court processes. And I think one of the things that has been absent, and I sort of blame myself for this, for not having been more engaged at an earlier stage, is the same weight being given to the Article 42A concerns of other children affected. So the sibling is protected if he was a witness to the unlawful killing, but he's not protected if he was in a different room, if he was not a witness. But the implications for his life and for rebuilding his life are the same. I want to thank your officials in particular for their engagement with me, their discussion on this issue. It is clearly not covered by the bill, but there is an ongoing issue in relation to how children affected by criminal issues of this kind are treated more broadly. And I know that other deputies have concerns about where that may go in terms of, for example, somebody being convicted of theft or assault or something like that, and their children being identifiable by virtue of the accused and convicted person being named publicly. This is a slightly different thing again, though. There is a subset of children whose privacy rights are impacted by this, and this bill doesn't square this away. There's a broader policy piece of work to be done. I appreciate that. But I also know from experience that could take a year, 2 years, 3 years to think about that in sort of homicide review very, very generally. I didn't put down an amendment to this because I know from a process perspective, it is essentially, the bill, this House wants the bill to happen quickly. There's a measure of speed around it. And I know in any event, you would have to go back to the Attorney-General and indeed back to Cabinet to have that discussion. And it does complicate this bill very considerably. So I know for myself, there's no point in doing that. But I do have to put on the record of the House these concerns. I worry that this issue will come up by way of judicial review in any event, that the court may end up looking at this under Article 42A in any event. And if that is so, I want to have flagged this, and I'm not trying to be unhelpful, I just want to take the time to flag it on the record to identify that this is a class of children who may be so affected, and that the implications for them and their lives, because of the possible behaviour of media, are very significant in trying to rebuild a family life with somebody who has committed an unlawful killing, yes, but not guilty by reason of insanity, which we think about and treat very differently to everything else. So, look, I support the bill, I support the amendments, but I just have to take this opportunity to put this very strongly on the record again. Thank you.
Very much, Deputy. Any other member wishing to contribute at this point? I'll go back then to the Minister. Minister, if you'd like to respond.
Thank you, yes. Just maybe to specifically respond to Deputy Carroll McNeill's point, and I am very sympathetic to the points that she has raised, and on foot of her raising them the last time we spoke in the Dáil, I asked my officials to engage with her and to explore this potential change. What became very apparent was that this, as the Deputy has outlined, is quite complex and in some cases goes outside the scope of Section 252. So, you know, obviously the intention of this bill is to try and restore the thought that had existed before the case in October last year in relation to Section 252. But what I will give to Deputy Carol McNeill and my officials have is a commitment to explore this further, to look at how this could potentially be addressed, whether it's something that would need a miscellaneous bill or otherwise, I'm not sure yet. But I will absolutely commit to looking at this and exploring it further, acknowledging the cooperation and the spirit of cooperation that Deputy Carol McNeill has raised her point this afternoon, and thanking her for her support for the overall piece of legislation, and just to thank all deputies for their support in progressing this as quickly as possible. And I think that's why it has progressed as quickly as possible, because there has been cross-party support in